Okay, so just to kind of welcome us all here today, this is our webinar on Rhode Island, our cannabis update, looking at some of the draft rules, enforcement trends that we've seen over the past year, as well as upcoming license opportunities. Both Casey and I are from Vicente LEP. We primarily focus on, only representing businesses in the cannabis space, have offices across the country. I'm an attorney here at Vicente. I've been practicing in Rhode Island since 2012. And am finally very excited to see a little bit of movement, now that we're have the commission set up, kind of leading into new opportunities on the horizon. Casey, do you want to give a little background of yourself as well?
Sure. I'm Casey Lever. I'm the Director of Regulatory Compliance at Vicente here, and I focus on the East Coast, or just kind of the eastern states here. Really focused on operational compliance, taking a piece of paper and making it a full compliant operation, helping our clients through inspections processes, floor plan design, reviewing potential pesticides, things like that. Really everything from soup to nuts on how to operate a compliant business, and maintain those operations as you successfully navigate in different states.
Awesome, thank you. Okay, to kind of orient ourselves before we kind of dive into more of the specifics about upcoming licensing opportunities, we're going to just do a quick kind of look back at what's happened in Rhode Island, since medical legalization at the outset. We're hopeful that this section of the webinar will provide a little bit more insight into current market dynamics and help inform kind of decision making going forward, if you are thinking about, new retail licensing in the future. Give the next slide, please. Thank you. So we first saw legalization in 2006, and this was really a true medical market, where the cultivators were, you had more of an assigned cultivator working directly with patients. I think that because of that sort of foundation of the market, that it has been kind of highly regarded as a quality industry, with high quality products, that have been available, again, kind of strictly to patients since 2006, legalization happened. In May of 2022, we finally got the Rhode Island Cannabis Act, which legalized adult use. It also created the Cannabis Control Commission. Currently, the medical cannabis program is overseen by the Office of Cannabis Regulation, which is within the Department of Business Regulation. And right now we're in kind of a unique transition period, where OCR, the Office of Cannabis Regulation, continues to be the governing body, that's kind of overseeing the existing medical and hybrid program in Rhode Island. The commission at the same time is working on proposed rules and will become kind of the regulatory authority after we see final rules, but we're in this kind of unique transition period. So shortly after we had the legalization, Rhode Island, to its credit, moved very swiftly to allow hybrid licensing for all the existing medical operators. One of the reasons why this is important when there's legalization is because providing access quickly by allowing kind of medical operators to obtain adult use licensing tends to really mitigate the proliferation of an unregulated market. So in some other jurisdictions where, you'll see legalization, but then a very slow rollout of licensing, or places to buy regulated products, it creates just kind of this void where there's a lot of kind of unlicensed, dispensaries or businesses that are entering the space, and ultimately making it more difficult for licensees to operate, and kind of inviting unregulated competition. So very much to Rhode Island's credit, they quickly moved. Hybrid licensing was available. I think the Rhode Island Cannabis Act was signed into law in May. And then cultivators were able to apply in July so that they could have product available for retailers who were authorized to start selling on December 1st of 2022. Next slide, please. So I'll just stop, kind of talk quickly about what we saw on the hybrid licensing application. If you're applying for a new license, this isn't going to be directly applicable. We'll talk more about what that's going to contain. But at the same time, it does provide some insight as to what OCR has already done, and probably provides some direction for what the future applications are going to look like. For hybrid licensees, they needed to ensure that they submitted a plan to ensure that there was going to be reserved product for patients, so that it wasn't just flipping adult use and then kind of the patients in Rhode Island were not having access. Needed to submit operational policies and SOPs, but there's been kind of, again, a focus on ensuring that there's some consistency between medical rules and hybrid rules, to ensure that it's not kind of creating just a disruption in functionality of how these businesses are running. The hybrid retailers were also required to enter into a labor peace agreement. That was part of the legislation of the Rhode Island Cannabis Act, and was different from kind of how medical operators were operating previously. So seeing some changes to the market, but in a lot of ways, for the most part, existing medical licensees were able to enter the market quickly by submitting hybrid applications and getting approvals from OCR. Next slide, please. Just looking at kind of the current licensees, this is going to inform kind of market dynamics and what exists there now. There are currently 7 licensed hybrid compassion centers. Compassion centers are a separate license type from, just retailers. Compassion centers are allowed to essentially be vertical and self-sustaining. 5 of the 7 licensees have hybrid grow operations. So while I'm sure that, they're kind of sourcing product from all over the state, they are able to kind of enter the supply chain on their own as well. There are also 60 licensed cultivators. And because of kind of this disproportionate amount of cultivators, particularly as compared to existing retailers or compassion centers, I should say, there is currently a moratorium on any new cultivator licenses. That moratorium is going to be in place for 2 years, starting once the final rules are published. And once that time period is up, the Cannabis Advisory Board and the commission will kind of undertake this review to determine whether or not other cultivation licensees are required to kind of satisfy market dynamics and the supply and demand within the state. I think that, this has kind of been, while this moratorium is not necessarily probably an exciting thing for operators who are hoping to get into the industry on the cultivation side, I do think that, a lot of the reason why this program is being rolled out the way it is to ensure that there are additional retailers that can sell product for the licensed cultivators. Similarly, if you are interested in getting in on the cultivation side, but not less interested in the licensing or, potentially buying a license, there are no current restrictions on IP licensing agreements in Rhode Island. We could see more through the proposed regulations. But there is, avenues to consider if you want to get your brand into the state. Casey, you want to
I'll take this one.
talk about
Can you hear
so
me?
far?
Okay.
Thank you.
So just looking back in 2024, we want to take a look at enforcement actions when you're thinking about entering any new state, or when we try to look ahead in what 2025 may hold and how these new licensees and new, regulations will be enforced. So in 2024, a grower was issued an $8,000 fine for failing to properly track samples of marijuana given to employees. That we're going to kind of touch on in the next couple slides, but commonly referred to in other states as a trade sample or a vendor sample. There are tracking requirements both involved in your inventory tracking system, Metrc, as well as other logs and different systems in place to ensure that you don't exceed, the samples that are essentially given out, which can lead to diversion. Also, another grower was issued a $10,875 fine for not properly testing quality control samples of marijuana that employees took home. Now, the regulations do allow for quality control samples. It's not like it went out the back door, but they do have to be tested. This, again, it kind of tracks with other state regulations. But in this case, in 2024, we did see enforcement action around these 2 points. We'll go to the next slide. All right, so let's look at 2025. The CCC released the proposed adult use regulations on January 8th. You're in luck. You still have 2 more days to submit any public comments on that. Once the public comment period ends, the CCC will review all comments received and evaluate whether to make changes to the rules based on those comments. They're also going to prepare a concise explanatory statement, which includes the reasons for not incorporating any changes suggested by the public, and a description of any changes made between the text and the proposed rule and the final rule. Just on a side note, something to ever reference if you're wondering in the future, let's say it's 2026, and you're wondering about a certain policy decision or interpretation, these concise explanatory statements are often a place where you can get some of that insight in writing looking back. And kind of, you might be looking later as an operator, let's say you get licensed and you're just a little lost on an interpretation. Sometimes those statements can really provide a lot of information. So glad to see that this is something that we're going to be able to have access to. But again, think about these public comments as we're kind of going through what some of the high level and some random kind of tidbits that I did pick out from the proposed regulations that just want to bring to your attention as something to consider if you're thinking about entering the state. And a public hearing on the regulations was held on January 24th. And if you want to see those proposed rules, you can find them available on the CCC's website. And that's the Rhode Island CCC, not to be confused with the Massachusetts CCC. And we'll go to the next slide. Okay, so again, this is not intended to be comprehensive, all-inclusive. These are just some things in the proposed regulations that I'm going to bring your attention to and things that I found interesting. A lot of it is almost exactly the same as what it was in the existing or what it is in the existing regulations. So if you're an existing operator, there's not going to be too much of an operational hurdle, but you do have an opportunity again until the 7th to provide some feedback and any changes that you'd like to see. What Rhode Island does is they actually provide a cannabis equivalency table. So it does a good job of providing, what is 1 ounce based on each different product type. And 1 ounce is important, as you'll see later, because that is the limit, the equivalency limit for the sale for an adult use consumer. So you're going to want to get used to what those are. They're going to be incorporated into your point of sale system. But Rhode Island is one of the more unique states in that it does really drill down and give you transparency in those equations. So you can take a look at that. Again, largely the same as medical. Now, the edible and ingestible kind of dosing limitations, same as the existing medical, that a single serving can't exceed 10 milligrams. Multiple servings can be placed together in a child-resistant and resealable package as long as they don't exceed 100 milligrams. And multiple packages can be bundled and sold together as long as it complies with the above and it doesn't exceed the amount a purchaser can possess, ultimately. For liquid form, if it's packaged as a single serving unit, the container may be sealed using a metal crown cork style bottle cap. Again, same language or similar languages in the medical existing regulations. If it's a multi-serving unit, it has to have resealable cap or closure to maintain child resistance. And if it's a multiple serving container there, it has to include a measuring device such as a measuring cap, cup, or dropper with the package that goes with the retail ready product. And hash marks on the package do not qualify as a measuring device. Now, total tincture limits are 500 milligrams. This is a little bit of a pivot in the language from what we've seen in the existing medical. The existing medical calls out this exceeding 500 milligrams on the concentrate side, but then in the proposed regulations, that same language doesn't get transferred over. If anything, it just actually addresses tincture limitations. Okay, another important piece as you're considering entering this market, particularly if you're looking into a speed to market, there is a product approval process. Every product must be approved as a retail-ready cannabis product and added to the approved retail-ready product designation list prior to sale or distribution. The commission isn't going to approve a product if it's received information, data, or research that the product is not safe. And when you actually apply for the product's approval, you have to self-disclose if you know of anything or any research that would indicate that. Now, that really can extend if you're coming from another state, if there's been a recall, if there's been any recent, I don't know, FDA information on a particular ingredient that was used. So something to consider is that, you not only do you have to self-disclose, but if they receive any information that says this product's not safe, the product won't be approved. And of course, everyone's favorite, if there's anything about the product that targets or is appealing to minors, it's pretty broad, pretty subjective, but definitely something to keep in mind when you are designing your packaging or your product generally. If you're coming from a different market, every market's a little different, and there is some subjectivity in what is appealing to minors, but to be conservative, always back away from anything that you even think might not make it. Next slide. Oh, there we go. A product will not be approved if, and now they actually go into different categories here. For vapes, you can't have any flavoring or coloring that has been added except for flavors or colors solely derived from cannabis or hemp and have been procured in accordance with applicable Rhode Island law. That's important for anybody who's talking about bringing in different terpenes or any other ingredients that flavoring or coloring that may not be derived from cannabis or hemp that you currently are using in any other state. Now, if there's any unapproved additives that have been added to the product, including but not limited to cutting agents or chemicals such as nicotine, don't see that too much, but that's another reason a vape would be approved. Smokable products, if the product has been combined with tobacco, nicotine, caffeine, or any other substance that has been approved. Now, for infused cannabis products, again, if it appeals to minors, whether it's the shape, the color, the placement, anything along those lines can also disqualify it as, something that can't be approved. If it's not a geometric shape or is in a shape that appeals to minors, such as human shape, stars, hearts, animals, cartoon characters, or anything enticing or something that the commission determines to be enticing to minors. If it's in the shape of a cannabis leaf or plant, if the product is bright or neon color, if it, has a resemblance to any existing consumer products, including foods, snacks, candies, beverages that do not contain cannabis, or it could cause a reasonable confusion as to whether the cannabis product is a trademark product. So the typical one is, a Reese's peanut butter cup. That would be an example of that could cause customer confusion as to whether it is a trademark product, particularly if it's orange, has the Reese's font. Things like that will, get the product to be in a place where it might not be approved. All right, so some of the operational considerations, if you're considering entering the market, is Rhode Island's a metric state, which is wonderful, depending on how you look at which inventory systems you're comfortable with. If you're not familiar with some of the inventory tracking systems, Metrc essentially tracks from seed to sale or seed to waste, all the way from, again, seed through the process, through flour, oil, finished product, off to retail, and ultimately out to the customer. There's a lot of information with how that is within Metrc, and it all gets transferred through the whole process. The CCC will have insight into Metrc. They can see those movements. They can see, test results even. They can, there's a lot of functionality within that system. So if you're already comfortable with Metrc, you know what you're getting into when it comes to the inventory tracking in Rhode Island. Quality control samples, as referenced in the enforcement action, there you would be allowed to have a sample of the licensee's own product, provided for internal quality control and product development purposes. Some states don't have that. Rhode Island does. It's a great opportunity, to kind of inform quality control and inform, whether or not a product is worth continuing. Trade samples, similarly, right? It's the amount of cannabis or cannabis product that has been designated by a cultivator or manufacturing licensee to go to retail for purposes of targeting, advertising, and product education. More on, do you want the retailer might have an employee that wants to try a product before they can necessarily talk to a potential customer about what the effects are. There's a lot of adult use customers kind of talk about that interaction at the point of sale where they ask, oh, what is this product like? And, that the bud tender's face or the employee that's helping you out kind of lost in that. Those trade samples will help kind of inform and educate the people that are working with you at your point of sale. We'll go to the next slide. All right, so an additional operational consideration is that formal agreements are required for acquisition of cannabis and cannabis products. So wholesale agreements is what I'm loosely going to refer to this as. A written executed contract or a purchase order is required for all sales or services and has to contain minimum terms. So if you're coming to a state that doesn't require these formal agreements, this might be a little bit newer, and definitely something as you're entering the state to think about, particularly if you are on a wholesale side. There's the minimum terms are date of execution, placement of contract, purchase order, the description of the product to be sold or services provided, pretty standard. Total price and per unit price of the product to be sold or services provided. The date or date range not spanning more than 30 calendar days for fulfillment of the order, performance of services, and delivery or pickup. The payment due date, which can be agreed upon between the parties. But if no date is specifically agreed to, the payment has to be made within 30 calendar days from the date of delivery or pickup. And contracts and purchase orders pursuant to this paragraph may not be modified, but may be canceled or voided by creation of a new replacement contract purchase order. Some of the packaging and advertising regs. Now, this is an existing requirement. So if you're already in the market, this isn't surprising to you, but definitely something that you might have the opportunity to make some comments on. Any logo or graphic that appears on retail ready packaging can't be larger than the required universal symbol. Now, the universal symbol has a minimum size and can be any size, but if you're thinking about bringing in packaging or really, launching your brand in the state, it's not likely you're taking something that, is kind of printed standard across your other markets and bringing it into the state, because this is something you're going to have to consider as the size of those logos. But again, you've got till the 7th to make some feedback, put some comments in on that. Advertising means the act or practice of calling public attention to one's product or service. Now, advertising, varies state to state. In Rhode Island, this is how the CCC has defined what advertising is. It's pretty broad. Cannabis establishments must take reasonable measures to ensure that the advertising medium targets an audience of 85% of the population as reasonably expected to be 21 years of age or older. We see 85% a lot. So that's, one of the requirements when you're thinking about, doing any sort of public advertising in like a bar or anything like that. Just remember, you've got to have that audience data, and that cannabis establishments have to provide reliable, verifiable, and current audience composition data if requested by the commission. There's no definition necessarily of current, but you're going to have to use a judgment call on that. Nothing from a few years ago, I'm sure, wouldn't fly. And next slide. All right, off to Meg.
Thanks, Casey. Well, I saw that we got a question about IP licensing, so I thought that I would just pause, particularly since we were just going over kind of packaging, labeling, operational considerations. So just kind of from the 10,000-foot view, an IP licensing agreement, IP being intellectual property, is one way for brands to get into different jurisdictions without having actual licensed operations. Obviously kind of getting a license, owning a business, running a business, there's significant overhead. And so if you're a, wildly successful brand in Maine or Colorado or, any other jurisdiction, and you want to make your product accessible in the Rhode Island market, you don't have to get a license. One potential avenue is to essentially enter into an agreement that satisfies, minimum requirements, with respect to licensing, your brand. And that frequently includes, providing proprietary SOPs, in the way that your product is made and handled. So just kind of additional background for potential opportunities in Rhode Island. We've worked with a number of licensees in a variety of jurisdictions on similar transactions. So you'll have all our contact information at the end if that's something that is intriguing to you for this market. Alternatively, if you are excited about the upcoming licensing round, we're going to dive into that now. I do want to note that the proposed rules contemplate, product manufacturing licenses, additional compassion center licenses. There's been no indication that those are kind of on the near horizon, but we do expect the 24 retail licenses that are, mentioned in the Rhode Island Cannabis Act, and have been discussed by the Cannabis Control Commission, to hopefully become available within the year. Part of that's going to depend on the final rules. So just as kind of a orientation, as we move forward in the process, this is kind of only speaking about the retail opportunities coming up. First and foremost, the application selection process is going to be a qualified lottery. We've been seeing sort of an increase in this methodology of awarding licenses. A qualified lottery means that you have to satisfy certain baseline requirements. It's not really like a merit-based, it's kind of a pass-fail. So you have to pass in order to be entered into the lottery, and then you'll be assigned, lottery number, and licenses will be selected at random. We've seen this in, Minnesota, Kentucky, Maryland. I think that regulators view it as more of an equitable system than a merit-based methodology. And it also mitigates risks of litigation to a degree, right? I believe that's the rationale. For the upcoming retail licenses, there will be 4 licenses available in 6 different geographic zones. So within each of the zones, there will be 1 license set aside for social equity applicants, 1 set aside for workers cooperatives, and 2 will go to kind of general applicants that don't fall into the specific social equity or workers cooperative categories. Can we go to the next slide, please? Okay, so notably, I want to make sure this is on everyone's radar. The term applicant is defined in the Rhode Island Cannabis Act as a resident or business entity with a principal place of business located in Rhode Island, including a corporation, LLC, LLP, or partnership, in which 51% of the equity in the business is owned by residents of Rhode Island, and that entity is applied for a license. This residency requirement has already been challenged in a lawsuit that's pending in Rhode Island District Court, where essentially arguing that this is a violation of the dormant commerce clause, by prohibiting citizens of other states from applying in Rhode Island. We have seen more successful challenges to this on the just medical side. This matter was recently, taken up in Maryland, where the court found that the dormant commerce clause does not apply in the adult use market. So, kind of remains to be seen how this is going to play out and whether or not this definition will shift, what the commission says about it. But that is the law as it stands right now. So for planning purposes, You know, it looks as though there will have to be local ownership. The commission has moved to dismiss the lawsuit, basically arguing that this issue isn't ripe for consideration yet because they haven't started the application process. Like no one has missed out on an opportunity. So I'm somewhat expecting it to be dismissed and that we might not get further clarity on this until after, but I did just want to make sure that everyone was aware of this as kind of planning for entity considerations moving forward, as well as who your team is. Next slide, please. Okay, so social equity applicants, again, there will be a total of 6 of these licenses available, 1 in each zone. The definition of a social equity applicant is an applicant that has been disproportionately impacted by criminal enforcement of marijuana laws, including individuals convicted of nonviolent marijuana offenses, family members of individuals convicted of nonviolent marijuana offenses, and individuals who have resided in disproportionately impacted areas for at least 5 of the last 10 years. So the commission, I anticipate, will release either a list or a map of sort of the identified disproportionate impact areas before kind of moving forward to the social equity certification portion, which we'll talk about more in a moment. Some of the factors here will be in terms of analyzing whether or not you qualify as a social equity applicant, will be based on this 51% ownership threshold, and whether that's owned by someone who's, you know, been in a disproportionate impact area or been arrested, or there's this other sort of category for applicants with a minimum of 10 full-time employees, or has current employees who reside in a disproportionate impact area, have been arrested, can demonstrate significant past experience in or business practices that promote economic empowerment, or had income which does not exceed 400% of the median income in a disproportionate impact area for at least 5 of the last 10 years. So all of this is somewhat a lot to digest in terms of figuring out whether or not you may qualify as a social equity applicant. Certainly if you have qualified in other jurisdictions, if you had a nonviolent offense, but a lot of these definitions raise more questions than they answer because we're still waiting for more information, namely on the disproportionate impact areas. Also, does it have to be a conviction in Rhode Island? Could it be a conviction in another state? There will be kind of a process that the commission will run. If we can go to the next slide, please. This kind of digs into this a little bit. That will, I'm sure, be accompanied with FAQs, guidance documents to kind of parse out this information a little bit more. So what we're going to see, at least this is how it's kind of presented in the proposed rules, is a social equity applicant status certification application period and timeline that should be released by the commission. They are essentially going to say between this date and this date, prospective social equity applicants can submit materials demonstrating that they satisfy this criteria. And you can do this either as an individual, meaning, I personally was convicted of a nonviolent marijuana offense, so here are my records, and then, I, Meg Nash, would be certified as a social equity applicant. Or, I could start Meg Nash LLP and be the 51% owner. Casey could have 49%, and we could submit all materials to get certified as a social equity applicant as an entity. So again, we'll kind of get more information on this going forward. If you are going to seek certification as an entity, you will need to provide, your articles of organization and operating agreement, bylaws, and then the commission will be responsible for reviewing and evaluating applications and issuing notices of approval. If that certification is denied applicants will then have 10 days to provide alternative evidence. And if approved, then that social equity applicant will be permitted to apply for the 6 social equity licenses reserved in each geographical zone. So I expect that there to be much more information coming in the future on this, and this is kind of derived just from the proposed rules, so this is subject to change. But I would be surprised if it deviated too much from, the current proposed regulation. So wanted to make sure that was on everyone's radar. The other unique kind of license type here, and I think that this is really specific to Rhode Island, is a workers' cooperative, which essentially means an applicant that's organized under a specific chapter of Rhode Island law. So this specific chapter, Title 7 and 6.2, kind of defines these organizations as entities that may elect to be governed as workers' cooperatives under this provision by essentially making it more of a democratically controlled and operated by their own workers. So this is specific to kind of Rhode Island. And if you're interested in pursuing this route, be sure to kind of be mindful of this specific statute and the organization under this statute. I anticipate that there would be potentially unique forms or unique boxes to check on Secretary of State forms in terms of entity formation. So if this is something that is kind of interesting to you, let us know how we can best assist. Kind of poke around the Secretary of State website. But this is kind of a unique model that we haven't seen in a lot of other jurisdictions. Okay. So then for purposes of planning, we've included a map here that kind of breaks up the geographic zones and shows where existing hybrid licensees are for retail. So, as part of this process, you will need property as part of the application process. So you will need to identify the zone in which you're planning to apply, identify property, ensure that it's compliant with all zoning setbacks, and also ensure that you that the specific entity that you're going to apply, whether you're applying as a general licensee or a social equity licensee or a worker-owned cooperative. We've listed the geographic zones here. I am aware of some municipalities that have banned cannabis use, but for the most part, the state, and at the local level as well, has been very supportive. So the vast majority of municipalities will allow cannabis retailers, but there are some exceptions to that rule. So as you're sort of evaluating property, thinking about the upcoming licensing round, be sure to kind of cross-check local municipal code and zoning ordinances. What we're going to see with the application is kind of similar to what you'll see in Massachusetts or other states as well. You'll need an operations and business plan, inventory tracking plan, a financial plan, security and safety plan, a compliance plan, as well as this local municipal approval. So it does not look like from the proposed rule or the statute that the municipal approval will have to be in the form of, like a special permit, that you'd have to go through an actual separate permitting process. It appears as though, if you get a letter certifying that this location is compliant, that should satisfy that requirement. But again, kind of as we're kind of plotting a chart forward or a path forward, it's important to keep that in mind and ensure that zoning is in place for your prospective location. Okay. So while we're waiting for more information, what can we do to get started and kind of be prepared as more information comes available? First and foremost, kind of thinking about and determining what your corporate structure is going to be. And by that, I mean, are you going to be a C Corp? Are you going to be a limited liability company? Thinking about whether or not you will seek to qualify as a social equity applicant. If so, what member of your team satisfies the 51% threshold? Will it be a worker-owned cooperative? And kind of going through those boxes carefully in order to get organized in Rhode Island, and then following up with filing at the Secretary of State and any kind of governance documents that would apply, whether it's an operating agreement or bylaws, depending on the entity. In addition, both the statute and proposed rules indicate that there will need to be some demonstration of property control. The proposed rules specifically mention a lease or a deed. But in prior rounds of licensing, letters of intent have been accepted. Again, that was through the Office of Cannabis Regulation as opposed to the Cannabis Control Commission. So there's, a relative level of lack of predictability, with just kind of new players involved. So we'll need to wait and see, but again, I'd be surprised if an LOI wasn't an option, in order to kind of, again, make this round of licensing more accessible, with respect to kind of initial capital. The zoning approval, I've mentioned this frequently in the last few minutes, but it can be kind of a tricky thing to get through. So I just want to make sure that kind of the property control, the zoning approval, both of those pieces usually take longer than you want them to. So kind of getting started on that now can never hurt. Similarly, access to capital, thinking about kind of how you're going to fund your operations. As far as we know so far, with respect to kind of minimum qualifications, there isn't going to be a threshold amount that you have to demonstrate. The application fee is $7,500 for general applicants and worker cooperatives. It's a sliding scale for social equity licensees, kind of over time. If you want more information on that, just let me know. I'm happy to pull that information for you. And the annual renewal fee is $30,000. So just fees alone is not a small amount of money to get going, never mind kind of the capital expenses related to, labor, equipment, security, the rest of it. So another thing to kind of think about early, similarly, your team, and this kind of applies at a couple different levels. Team being, if you're a social equity applicant, a member of your team has to be, meet that criteria. We're like that definition of applicant that we talked about with the residency requirement. So who are some of the individuals on your team that are going to satisfy these threshold issues to get you the certain license type that you want, or to satisfy the definition of applicant as it's currently in the statute? This also means kind of identifying people who could be a compliance officer or who can assist, with retail operations. So everyone kind of, has unique skill sets that they can lend. And typically you want to be able to highlight that in any application to really demonstrate that the individuals involved, or who will be involved in your licensed operations, really know what they're doing. So those are, I would kind of prioritize as the top 5 action items. Casey, I know you've been involved in a lot of different licensing rounds in Rhode Island and elsewhere. I don't know if you had anything kind of to add there for things to think about.
Yeah, I mean, certainly with the location, obviously is super important. Thinking about parking, things like that, they're going to actually make you successful, not just, if you get the application, you want to end up in a good location. Really thinking about your floor plan at the application phase, as it, my understanding is it will be submitted with your application. That's, a lot of the things that I work with our licensees on through this application process is really thinking about that location, building that team. Who do I really need from the beginning? Who's going to inform? and provide, information that's valuable in making these decisions. And again, I can't, stress enough on the floor plan, whatever you think your vault is, if you think your vault's big enough, it's not. So keep it big.
Always a good tip. So yeah, 3 tips that won't steer you wrong. Number 1, understand the regulations. Hopefully, the webinar today has assisted in that, to a degree. To the extent that you see things in the draft regulations that you want to push back on, another reminder that the public comment period is open through Friday. And there's information about how to submit that information on the CCC's website. So good to consider kind of letting your voice be heard before we get to final rules. In addition, start early. Again, like, you need more time than you think you do for property and zoning. So kind of take the time to think thoughtfully about that, where you're going to apply, looking at zoning, both the statutory state requirements as well as at the local level, in order to kind of really just get dialed in on that, because that really can be one of the biggest hurdles. And then, as we get additional information from the CCC, just be sure to kind of review all those documents carefully. FAQs, there's often a lot of kind of hidden interpretation and very helpful information, whether it's in guidance or on the commission's website, that you can kind of pull out from not just looking at the rules. It looks like we have a couple questions here. Some asking about the application fee. It is $7,500 for open applicants. I was just going to try to pull the fee schedule for social equity applicants, but I can send via email also. And then looks like we had another question: can landlords sign LOIs for multiple applicants? So I will say that in the last licensing round, I think was in the fall of 2020, and those licenses were awarded in 2021. And I think there was some properties that were used for multiple applicants. I'd have to look back to see if the OCR issued any guidance on that. But you can typically interpret, you can include contingency language in there, where the lease or the duty to enter into the lease isn't triggered until you receipt of a provisional license, to ensure that you're not stuck with a property that you can't use. Let me see. The 51%, one question. So does the 51% ownership rule only apply to the social equity license? So the 51% ownership rule, if you're trying to be a social equity applicant, an individual who satisfies that criteria has to be a 51%, or 3 people and their percentages add up to 51%, need to, satisfy that criteria. For general applicants, there is also this, definition of applicant in the statutory language, where it says 51% of the entity has to be owned by Rhode Island residents. That is currently in litigation. So we're kind of waiting to see where that lands. To my knowledge, it hasn't been kind of expressly addressed by the commission. So there is a 51% threshold for, residency, even if you're not a social equity applicant. So one of the questions is, when is the application process dates again? So we don't have those yet. They're not going to announce it until we have the final rules and regulations. So we now have the proposed rules, which won't become final until we kind of get through the public comment period, which again closes on Friday. So once the rules are final, then we expect the licensing round to kind of open up, but it looks as though the commission will need to run this social equity certification status program prior to announcing licenses, but hopefully we'll have more information on timeline soon. So the question is, do now all products have to be submitted?
Not as of right now. There's a product designation list, meaning like the certain type of product has to be approved. But the way it looks like the way the draft regs are written or the proposed regs is that the product itself will be registered versus the existing product designation list. But we'll see how, that transition plays out with the change from the existing regs to whatever ends up being final.
And I saw another question, will you need local approval before applying? You will need to include a letter that says this property that the applicant is intending to locate a cannabis business retailer at complies with zoning in whatever municipality you're in. You don't have to get, it doesn't say that you have to get like a special permit, kind of go through that process. So, I think that the answer is yes, but it's, more of a gradual approval from the town as opposed to like formal site plan review or special permit, or at least that's my interpretation of the way it's drafted. Couple other things I wanted to mention about the application process. So applicants are allowed to apply in every single zone. Obviously, that would be like a huge amount of real estate to have in connection with the application. But you are allowed to apply in multiple zones if you have, different properties, and you would be entered into different lotteries for each zone. If you won in both zones, you'd have to pick one. And it appears as though they're really trying to make an effort to make it challenging to for applicants to apply, multiple times. So some things that the cannabis industry has kind of experienced with this turn towards lottery licensing is that, one entity will submit thousands of applications to essentially try to, weigh the lottery in their favor, increase their odds. It appears as though Rhode Island is trying to be proactive to kind of prevent that from happening. So it is more of a fair and equitable process where you're not going to be able to kind of advance, one applicant over another. But again, more to be seen there.
And I just dropped the link to the existing product designations information if you're looking for more information on what's currently in place. It was actually, it looks like hasn't been updated since February 27th of 2024, but I just dropped the link in there if you want to go ahead and if you wanted to take a look at what's currently approved.
Casey. Well, as mentioned in the Q&A chat, in a few days or, shortly, all the slides, the recording, will be sent to all attendees. Our contact information is listed here as well as on our website. We'd be happy to help with any questions, and kind of planning and preparing for licensing in Rhode Island. I, for one, am, as a longtime Rhode Island attorney, am thrilled that there's going to be more opportunities there. And looking forward to more information to come from the commission.